Mr. Hinchcliffe.
My lords, where we got to at the end yesterday was we looked at the last part of Nokia, where the document had explained that in some circumstances it was beneficial to prevent or to allocate only part of the code space to implicit ACNACs, and it had those two parameters. If my lords remember, allowed T shift and allowed F shift, and the disclosure of Nokia is those parameters were to allow certain of the resource space to be used for periodic ACNAC and periodic CQI. And the reason why I took your lordships to that is because that's the disclosure of Nokia as to why you do that. And Apple's case, as we'll come on to, requires those parameters to be used to prevent the use of those resources for anything at all. And that isn't the disclosure of Nokia. So with that, can we then look at the judge's conclusions on Nokia? So that's core bundle tab 5 for the judgment, and I'd like to just pick it up just briefly with his conclusions on obviousness, some of which we saw yesterday, and then on to the alternative case. So that's paragraph 396. So first of all, the judge dealing with the obviousness case, he deals with the issue of 3 codes for data and 2 cyclic shift gap. And as he says in 398, he rejected the submission that it would be obvious in the light of Nokia to use just 3 Walsh codes. He said the skilled person would think the more room there was to space out the resources, the less likely there was to be adjacency and interference. That was an important consideration, given that the claim is limited to just 3 Walsh codes. And then over the page, the important finding we saw yesterday, which comes back in on my learned friend's appeal about the 2 cyclic shift gap issue, is that given the way the judge has interpreted in 401 code multiplexing structure, the code multiplexing structure of Nokia is the whole grid of numbers from 1 to 36 or 1 to 48, and not just those parts that are in use at any moment, depending on how many UEs are scheduled. And the judge gives an example. He says, it would not be the case that the code multiplexing structure of table B, and if my lords want to remind yourself what table B is, that's back in paragraph 369, you can see it, where we see all the resources being numbered. And the judge said it wouldn't be, the code multiplexing structure wouldn't be the single resource at res first equals 30 if there was only 1 UE scheduled. And nor is the code multiplexing structure just the first 18 numbers when all 18 UEs are scheduled. And that's because all those resources are available to be used. And what the Nokia algorithm does is order the way that they're allocated to UEs. He also thought that it was hindsight just to mentally shade in just 18 UEs, but that's a slightly different point. He then, in 405 and 406, he dealt with the issue of whether it would be obvious to put an unused cyclic shift after a CQI, keeping in mind that Nokia does obviously disclose the idea of having a mixed resource block. And he rejected the case that would be an obvious thing to do, for the similar reasons that he gave in relation to the other piece of paragraphs. And he then dealt with, in a couple of paragraphs, with the extra feature of the 810 patents, and I'll come back to that when we deal with the 810 patents. And then he moves on then to deal with the alternative case over Nokia at 411. And the judge says, I've held the claims of the patent don't require there to be a code multiplexing structure or for the mobile station to be used with it. They merely require the mobile station to be adapted to operate with the code multiplexing structure as defined in the event that there is one. And adapted means able without reprogramming. Now, just pausing there and focusing on the judge's use of able, what he means by that is the requirements that he'd set out when he'd construed code multiplexing structure earlier in the judgment. and in particular at 244. So my lords could just turn back to 244. And he says there in the second line, the mobile must of course be adapted to spread and transmit in accordance with it. A mobile which was programmed to put ACNACs or CQIs in places that the code multiplexing structure did not permit would not be so adapted and would be outside the claim. Now, the reason for stressing that is because it's not enough for my learned friends in trying to show anticipation, to show that the Nokia phone, programmed in accordance with the disclosure of Nokia as the code multiplexing structure, might, in certain circumstances, not do the wrong thing. And let me give my lords an example just to illustrate that point and what I mean. If, for example, we think of a Nokia mobile where the base station chooses a shift diff of 2, res first is 0, so it's going to start in the top left column, looking perhaps at figure B in paragraph 369 of the judgment. So in B, rather than the 0 resource being in column 2, row 8, it's in column 0, row 0. And if the base station only schedules a single UE, a Nokia UE would use that resource 00. And so too would a UE that was programmed to use a code multiplexing structure of the claim, because assuming that we've got the checkerboard and that's one of the resources that's available. But of course the Nokia mobile would be programmed to be able to use all the resources in, as we see in figure B, all the way through to resource 35, whereas of course a UE of the claim has code in it where it can't use the resources outside of the checkerboard, and it can't use those cyclic shifts that have been prohibited for either ACNAC or CQI use. So what my learned friend's case does on this part of the case, on Nokia, is of course it has to proceed, as the judge said in 411, on what the phone, the Nokia phone, has been programmed to do. But what she postulates is a series of parameters that the base station does, and then says, oh, well, the mobile phone could cope with it. And maybe in some circumstances it could, but it still would be a different phone. And it would, importantly, it would be a phone that was programmed to allow it to put ACNACs in any of the resource combinations, which the claim requires the phone of the claim can't do. And that was a key part of the judge's finding, as we'll see. So if we then go back to the judgments and back to 414, the judge records that there were 2 attacks, and the only one we need to focus on for the appeal is the one in 416. So that's num T shift as 4, which gives in principle 4 Walsh codes. Num F shift as 12, which is the length of the Kazakh sequence. Shift diff as 2, so in each cyclic shift you get a gap of 2. In each Walsh code you get a gap of 2. And to set allowed T shift to prohibit the use of the 4th block level code. So that's the hypothesis. And those are all parameters we accept in Nokia that can be used. And then in addition, in 418, we have the postulated limit of 18 UEs. Now, and what that would look like, I don't know if my lords want to go back and look at it, was the diagram we put in our skeleton. My lords have seen it with that. If those resources were all used in turn, you would have the 4th column available for...
Sorry, can you remind me which diagram you're referring to?
So it's our skeleton, which is core tab 4, and it is in paragraph 41 at the top of our page 15.
Well, indeed, but which of the two are you referring to? Because
yes.
If I've understood correctly, I mean, at this stage of the argument, we haven't quite got on to the point about the fourth column. So at this stage of the argument, we could focus on the left-hand diagram. Is that right? Although, of course, when you come on to the point about the fourth column becomes important.
Yes, I mean, I think obviously the fourth column is always there. That's our point.
Well, quite so. But Apple's case, as it were, focuses on the first three.
Yes. And my lord, I'll come on to that point rather than jumping ahead of myself.
Yeah.
So the judge rejects that case for 3 reasons, and the first 2 are related, and that's, as he says, as he's construed case management. Code multiplexing structure, it's the complete set of rules, and the rules as disclosed in Nokia can populate all the resources in the grid, and it's not just a 2 cyclic shift mesh. And I'll come on to deal with Apple's arguments in relation to that in due course. Then the third point is the fourth column point, that allowed T-shift wouldn't set the fourth column as being unusable for anything. What it does is it sets the fourth Walsh code as being unusual for scheduled ACNACs or implicit ACNACs, as Nokia calls it.
Just before you get on to that, I mean, you said the first 2 reasons are related. I mean, are they actually different at all? They're really just the same reason, aren't they?
It's the same reason, but the second one is making it clear that the number of UEs that the base station happens to schedule at any given instance doesn't affect what the code multiplexing structure is.
The mere fact that it's 80 UEs as opposed to 70 UEs doesn't magically transform the set of rules.
Precisely. That's the point. So it's an aspect of it. Whether it's 2 or 1, I don't think it's worth having an argument about. So then the third one is the fact that the fourth Walsh code is still available for transmitting data, and in particular the disclosure of Nokia is that it's available for transmitting periodic ACNACs, and of course the claim requires that there are only 3 Walsh codes available for transmitting ACNACs in its entirety, and indeed in the standards there are only 3 Walsh codes that are used. There's not, the fourth one just isn't specified. The judge then dismisses the point that was made that Apple tried to do about aggregating all the slightly complicated point in 420. The point that was run was that if you look at the standard and you aggregate all the different code multiplexing structures that the standard allows, depending on the parameters of NCS1 and delta shift push, you can find that all the different resources can be used for ACNACs. But as the point the judge is making is this is a false equivalence, because what you're doing is you're aggregating multiple code multiplexing structures in the standard, whereas in Nokia you have one code multiplexing structure that allows all of them to be allocated. And then in 421 he deals with the unusable cyclic shift point. And the key finding is at the end is that there's no parameter in Nokia that makes it possible to tell the UE not to use a completely unused cyclic shift, so that they all remain available. So we say, given that this argument proceeds on the basis of the judge's construction of code multiplexing structure, we say, given what Nokia is, his construction of code multiplexing structure inevitably leads to the conclusion that the Nokia phone is different to the phone of the claim. So, turning on to the reasons why Apple says the judge was wrong, and the main points, at least on the code multiplexing structure point, so 419.1 and 2, is they say it's just beside the point that the Apple phone, the Nokia phone could use all the resources, and it could use the fourth column for ACNAX. But we say that's just ignoring what the code multiplexing structure is. And it's again, the sleight of hand is shifting away from what the phone has been programmed to do, and where the phone is programmed to put its ACS and NACS, with what the base station might do. And the focus of this part of the case has to be on what is the programming of the phone, what can and can't the phone do as to which codes it can use and which codes it can't use. And the claim requires that only those that fall within the mesh can be used, and whereas Nokia, the phone can use all of them. And really, one can see this visually by comparing, we can probably do this from the judgment if that's open, so go back to paragraph 369 of the judgment, and figure B, that is, I think this illustration I'm probably not going to be dealing with the fourth code point, but just as the general point. That is, those are the resources that the Nokia mobile can allocate when you have those parameters. And if one compares that to what's accepted to be an illustration of the claim, which the judge illustrates in paragraph 214 of his judgment, one can immediately see the differences. There's only some of the rectangles have got numbers in them. The ones that are green can't be used for ACNAX. And we have the two red bands of the completely unusable cyclic shifts. And that simple visual illustration that's an illustration of the claim, and then what the Nokia one can do shows you that the Nokia UE is a different one to the one of the claim, because it doesn't have the code in it that prevents it from using certain of the resources. Now, one can see this. Perhaps this is a slightly complicated example, but I'm going to give it a go. So it's a point we made in our skeleton. If my lords go to paragraph 407 of the judgment, this is an illustration that what the judge refers to in these paragraphs is a bit of my cross-examination of Mr. Edwards, specifically in relation to the 810 patents, and we'll come back to this. But what we say, this shows and this illustrates why, in the case of the Nokia UE, the code multiplexing structure is the whole of the resource space. So what I put to Mr. Edwards in cross-examination was an example via a document where Nokia had been taken, and his suggested obvious modification of Nokia, which was to use the CCEs by way of implicit signaling. Now, obviously, our position was that wasn't an obvious thing to do, but I was exploring with him the consequences of his evidence as to what was obvious. And we postulated an example where there were less than perfect channel conditions, and so that CCEs were being aggregated to send the downlink allocation messages. And so rather than it being a single CCE, sometimes you've got two CCEs, sometimes four, sometimes eight, because those were the available aggregations in the standard of priority data. Now, of course, what this illustrates is you only get the impression of a two cyclic shift mesh using 18 UEs with Nokia's allocation algorithm if you always allocate using one every resource and there are no gaps. And what this figure shows is if you consider a cell where there are 6 UEs, you see that in allocation 2, 6 UEs. The first UE gets an allocation using one CCE, so its resource goes in in column 0, row 0, where the 0 is. That's the first one. And it's used just one CCE. So the next CCE is available for the second UE, and that goes in column 0, row 2. But this one has used 4 CCEs in the downlink to be told. So the next 3 CCEs have already been used and are not available for the signalling. So the next phone, using Nokia's algorithm, has to be given the resource that's numbered 5 in column 0, row 10. And so on and so forth. And what this shows is even with, when you get to the 6th UE, that goes in resource position 19. So this is an illustration that Nokia's code multiplexing structure is the entire resource space, and in circumstances where you don't allocate the first 18 resources to the first 18 phones, you will break out of the 2 cyclic shift mesh that my learned friend wants to say is her code multiplexing structure in this hypothetical example. And so, in fact, it may be a point of detail, but the 18 UE limit isn't actually what she needs to get to what she says the claim is. She actually needs a limit of saying you only allocate 18 and you always allocate the first 18 resources, you never have any gaps. So then, if I can then turn back to paragraph 419 and deal with the 4th column point, and I think we'll probably have our answer to this, because it is obviously related to the general point that the whole code multiplexing structure, the code multiplexing structure is the whole resource space. And again, Apple merely say that it's beside the point that in Nokia the 4th code is available to be used for periodic ACK. But in our submission it's not, and the judge was right, because a UE that's programmed in accordance with Nokia would be able to use that 4th code for those ACK symbols, and a phone complying with the claim would not, and therefore they will be different phones to that extent. And the code multiplexing structure still is all 4 codes.
At the risk of asking a question which may have a very complicated answer, which doesn't matter, what Penny's just dropped something that's been bugging me for a while. If there are 4, I thought the reason for having 4 Walsh codes in some circumstances was because there were 4 symbols, 4 slots in the 7 resource elements going horizontally. If you look at the resources that way, 3 were for use for pilots and 4 were for data, and that was why people would talk about having 4 Walsh codes. But if you're only having, and I understand the point you're making about what you just made, you say actually there are still 4 Walsh codes, 3 of them are being used for implicit, and 1 of them is available for periodics. But why would you, in the invention, why would you only have 3? Is it 3? Do you have 3 out of 4, or is it just you just have 3?
Yes. So in the claim requires that there are 3 codes. Mm-hmm. Claim 1. There's then a subsidiary claim that was relied upon as being independently valid that says they are 3 length 4 codes. So there's a specific claim to that. And then in the standard, and I can show my lord if it helps.
Just tell me.
That there are, the relevant standard has a table saying these are the orthogonal codes to be used, and there are 3 length 4 codes, and the 4th one is just omitted.
Okay.
And so part of the invention, part of the issue on the obviousness case, as we touched on briefly, was this idea that it was counterintuitive to go to actually have. So I want to be spreading my UEs across the code space to avoid interference, but then at the same time discarding one of the 4 codes. And part of the invention is actually when you do that, you still get a nice...
I may have misunderstood completely, but I thought the question is why don't you have, e.g., 5 water codes? And the answer is because of...
You can only have 4.
Well, exactly. That was the point I thought Arnold was asking about. The question is, why can you only have 4?
So you can only have 4 because you've only got 4 symbols. My law's right, and therefore you need to spread across the 4 symbols. So you are the maximum length is the length of the code is 4. That gives you 4 available codes.
Yeah.
But you don't have to use all of them. And the standard.
But what the judge found is that as a priority date, it would be counterintuitive to use less than the full 4 that you can.
Yeah. Okay.
But obviously that issue is not one that my lawyer
No.
to be worried about. So that.
Thank you.
If you're moving on, can I just try to clear up a couple of irrelevant things? The way you clear the row, as the judge explains on Apple's case, is by applying the parameter allowed F shift.
That does a row, yes, my lord.
We see the pretty lattice, as you say in paragraph 41 of your skeleton, accommodating numbers from 1 to 18.
Yes, my lord.
If you cleared a row, do you still have 18?
No. So this is another slight oddity in Apple's case, is that if you clear a row, you either have 17 or 16 left.
Yes.
You can have. And then you can put a CQI in that one row.
Does that mean you can't have 18 phones and still get the lattice?
No, you can still get a lattice. What you can't get with at least one row used for CQI and at least one unusable is you can't multiplex 18 because you have to lose at least 3 ACNAT resources. So you go down from 18 to 15 and then maybe you get one CQI back, so you get to 16.
So I'm sure I'm confusing myself, but just so I understand, I followed that. So you've lost some of your spots, but you can still have 18 phones.
No,
No.
you can't.
So if you've cleared the row, you can have a maximum of 17 phones, can you?
If you clear just one row and it happens to be you pick a cyclic shift that only has 1 in it in the checkerboard rather
Yes.
than 2, then you're down to a maximum of 17 UEs in a cell.
And then if you've got the clear row, afterwards
You've lost
it's
another
16.
2.
You lost another 2. But
Two, sorry.
But you may decide to use one of those for a CQI, so arguably it goes back up again by 1.
Revert for a moment to the 18. Ignore for the moment clearing the row. You've got your pretty lattice. If you're applying all Apple's parameters and one phone drops off, so you've now got 17, what shape do you then get?
Well, our case is shape.
Well, I mean, by comparison with your diagram in paragraph 41 of the skeleton, did we just lose 18 at the top right, or did we lose anything else?
Well, because this gets into difficulty because our case is that the code multiplexing structure remains all those, for Nokia, remains all those available resources.
Yes.
So the fact that you don't schedule, for example, a phone and use resource 18 doesn't change what the code multiplexing structure is, because that resource is still available to be used.
And I understand that case, but just in terms of the pretty pattern, if a phone drops off, what you lose from the pattern is number 18, so it otherwise remains the same.
Yes.
Yeah.
So, well, I think that those are our answers to the points, the challenges to the judge's findings in 419, Roman 1 to 3. the 420, which is the mixing and maxing point, I think I've probably dealt with in enough detail. My learner friend didn't really engage with why the judge was wrong in relation to what he says in there, that it's not legitimate to mix and match the code multiplexing structures in LTE and say that it's no different to Nokia. For any one set of combination of NCS1 and delta shift push in the standard, and particularly the combination that we say falls within the claim, there are a subset of resources that are usable which fall within the mesh, and some that are not usable. In Nokia, even with the parameter delta shift diff of 2, all of them remain usable. All that happens is that they get dolloped out in a different order. So that's that point. The CQI point in para 421, it's not, didn't detect any challenge to the judge's findings because it's plainly right that there's no parameter in Nokia that allows you to ensure a completely unused cyclic shift, so therefore the phone itself doesn't have any ability, it hasn't got any code in it that tells it not to use it. And all that Apple says is, well, the base station could decide to block out 3 by using allowed F shift. And when I say block out, what I mean is prevent from being used for implicit ACK-NACs. And the base station could decide only to tell the UEs in the cell to use the middle one, and therefore the 2 on either side wouldn't be used. And again, what this sleight of hand that's going on here is this is talking about what the base station is doing and not focusing on what the phones are and aren't able to do. And it ultimately, all this point comes back to the same answer, it's just in different circumstances, is because because the phones are able to use all the resources in Nokia's code multiplexing structure, they are not adapted to work with the code multiplexing structure of the claim, which requires that there is an unusable cyclic shift that follows on from a cyclic shift used for CQI. Because there's nothing in Nokia's phones that prevents them from being able to do that. Whereas LTE phones, the upshot of the code is that they can never use any prohibited cyclic shift. And so we say that the judge on this issue of anticipation by Nokia was essentially right for all the reasons that he gave. So unless I can help you on that topic anymore, I'll move on to the 810 patents. Now, I think my laws probably have the extra features of the 810 claim in mind, but can we just make sure we have a look at them just to get them straight? So that's supplemental bundles, tab 4, should be the 810 claims. And the 2 extra integers over the claims of the 549 patents are 1b, a receiver configured to receive control information on the control channel element, CCE, and then over the page in 1l, the CCE is associated with a physical uplink control channel, push, and the push is determinative of the cyclic shift, and so on and so forth. And as we say in our skeleton, although the grounds of appeal take 3 points, they take the interpretation of Kobe points and the construction of the claim points and obviousness. In my friend's skeleton, the obviousness case is developed extremely thinly, and my Lord Justice Arnold highlighted some of the problems with it. I'll come and address you that in due course. But it seems to be implicit in the argument that if they win on construction, they win on obviousness. And as we've given a specific reason, specific illustration in our skeleton as why it's not so straightforward. But I'll come on and address that point more generally right at the end. So if we can start first with Kobe, and I think we can take this from the judgment, because the judge sets out the relevant bit of the minutes. So 4 tab 5.
Before you do that, Mr. Newey, can I just get my bearings in terms of the premise? So we're looking at this claim relative to Nokia.
So the premise is that my learned friend hasn't persuaded you on construction or infringement, but has persuaded you on Nokia. Because if she doesn't get anywhere on Nokia either, this issue doesn't matter.
Yes. So if Nokia doesn't anticipate the other claim we were looking at, then this point doesn't arise.
Doesn't arise at all.
Yeah. But if Nokia does anticipate the other claim, then this claim has an extra feature in it about the implicit signaling. I see.
Yes.
Okay. Yeah.
And anticipating 549 isn't enough for her commercial purposes. So we were going to go to paragraph 175 of the judgment. And the judge sets out there the resolution or the agreement from the Kobe meeting. For non-persistent scheduling, the ACNAT resource is linked to the index of the control channel used for scheduling. Now, the first issue the judge decided was whether the agreement as a fact was common general knowledge. And although he'd concluded that it didn't necessarily follow that just because something was recorded in the minutes, that meant it was common general knowledge, he looked at the number of places in which the Kobe agreements had been referred to and decided that based on the weight of that, it would have been common general knowledge. And we don't disagree with that conclusion on appeal. But then there was the dispute about the meaning of Kobe. Now, at trial, Apple's case, its primary case, had been that it would be understood as meaning that the linking would be to the index of the control channel element. And that had been Mr. Edwards' evidence in his written reports. And I don't know if we would need to go to them, but it's, if my lord wants a reference, it's supplemental bundle tab 9, and it's paragraph 159. C, I think. Yes, 159C. And his evidence had progressed in when he was dealing with the claims of the 810. He'd said, well, this extra feature is obvious because that's what the skilled person would understand Kobe to mean. So he had almost no extra lifting to do to get to this feature as he understood Kobe. Now, as a fallback at trial, Apple argued as a matter of argument that it would be also alternatively understood to be ambiguous. And it's that alternative point that's now pressed in this cause. But the judge, as my lords would have seen, held that he didn't think Kobe would be understood to be ambiguous, and that's paragraph 179. And he held that it was the index of the control channel on the downlink would be used to signal the uplink resource. Effectively, it means what it says. And he then gives his reasoning in 181, and as my Lord Justice Arnold noted yesterday, possibly even on Tuesday, although he says the skilled person, he doesn't think the skilled person would be likely to go back and look at the 472 documents. He does, part of his reasoning is that the 472 document does support his conclusion. So, whereas my learned friend's position on appeal is that it would be wrong to go back and look at the documents. We don't agree with that. One can look at Kobe on its face, its meaning is clear on its face. But if you do go back and look at things like the 472 document and some of the other documents I'll show you, Your Lordships, in a moment, they're all consistent with the way the judge understood it.
So let me see if I've understood that submission correctly. Do I understand from that your primary position is that the Kobe agreement is unambiguous on its face, means what you say it means. But in the alternative, if the skilled person had doubts as to what it meant, they would look at the cited document 472, and that would resolve any doubt they had in favour of the meaning for which you contend.
Yes, and also one can look more generally at some of the earlier documents and some of the later documents as a way of interpreting it, to be comfortable that
That's a different proposition, because the point about 472 is that it is explicitly cross-referenced. And not merely explicitly cross-referenced, it's cross-referenced as providing the context for the agreement.
Yeah.
Whereas as soon as you go beyond 472, one has to ask oneself, well, why does the skilled person do that?
Yes, so I don't think we say that the skilled person would do that. But if one's trying to do the exercise of trying to understand what the agreement means, one needs to look at the context in which it was made, and you can see that it's consistent. Well, I'm going to come on to this.
I don't understand that.
Well, maybe I'm getting ahead of myself once again. I was going to come on to this in relation to the issue of whether the judge was entitled to say that the Panasonic document was a diplomatically phrased attempt to change the agreements. Because what we can see when we look at some of the documents beforehand is that people...
Well, on ordinary principles, a subsequent document doesn't change the meaning of a prior document.
No. But they can give the court...
So, I'm sorry, what I'm trying to get at here is what is the issue with which we are concerned? Because there's two different potential issues. Well, first of all, the judge has found as a fact that there was an agreement, and I don't understand that to be in dispute in this court. He's also found as a fact that the existence of that agreement was common general knowledge, and that is also not in dispute in this court. The next question is, what does the document that records that agreement mean? Now, as it seems to me at the moment, that is a question of interpretation of a technical document, and it's no different from interpretation of any other technical document. So the skilled person reads it and says, well, what does it mean? And we have a debate about that. And then the fourth question is, once you've established what the meaning of the document is, you then have the question, well, what does the skilled person think in the light of that? And what do they do in the light of that?
Yes, and I think what we are dealing with is what was the common general knowledge understanding of what Kobe meant, which probably is exactly the same point of how would the skilled person reading it, what would they understand it to mean? Because where this comes back in...
Well, I think you're correct to say that in principle you could have a debate about what the common general knowledge is, and which is not necessarily the same thing as what the document means as a matter of interpretation. In principle, that must be right. But is that realistic in the circumstances with which we're concerned here? Because the reality here is you know, this is all about an agreement that's been documented. And so everybody looks at what the document says.
Yes, so we have to construe the document through the eyes of the skilled person. If the skilled person thinks it means X, then that's probably a different way of saying that's what the skilled person's common general knowledge is, the meaning of the document.
And that's the judge's reasoning, isn't it? He finds as a fact that the agreement is common general knowledge, and then he says, well, what does it mean?
Yes. Oh, that's right.
And I understand your submission that in construing the document, it's legitimate to have regard to the other document, which is explicitly cross-referenced. What I'm having a bit more trouble with is the idea that you look at the context more broadly, particularly if it's subsequent to the date of the document.
Well, we don't, for our submissions, we say that 472 amply supports the judge's conclusions as to the meaning of Kobe, and it sets the context. And perhaps we can just turn it up briefly.
Just before you do, following up on my lord's point, I see the judge at one point says that there's a difference between looking at what real people thought a document meant, which is ultimately a matter of law, and looking at what they thought could be done with it. Is looking at what real people thought a document meant a matter of law?
I think it's the construction. I think that's the point that my Lord Justice Arnold just been putting, that when one is trying to find the meaning of the documents.
But you were saying, it seemed to me to make sense, that you construe the document through the eyes of the skilled person. And if you're construing it through the eyes of the skilled person, that doesn't sound like a question of law. That sounds like a question of fact.
Well,
No, that is a question of law.
It is a question of law, isn't it?
But there is a slight confusion, because what real people actually thought the document meant is, strictly speaking, inadmissible, because that it's a question of interpretation for the court. Where potentially you might have a difference is on this question of ambiguity, because I think there is some case law that says if the issue is it ambiguous or not, then possibly there's a little more room for evidence than on ordinary principles of interpretation. I think that's probably what the judge has in mind.
but we certainly don't say the judge was wrong to have regard to 472 in supporting his interpretation of Kobe and finding it clear and effectively meaning what it says, being the index of the channel. And we also agree with him that 472 does support his interpretation, because we see multiple companies were asked for their view, and all of them said, yes, let's use the index of the channel. No one said, well, hang on, what does that mean? That's ambiguous, I don't understand it. Nobody said, doesn't make any technical sense. And nobody said, why don't we use CCEs instead of the channel? They all just said, yes, let's use the index of the control channel.
Sorry, I interrupted you with my irrelevant point.
So the point that's put by Apple on appeal is that interpreting the Kobe agreement as the judge did makes no technical sense. And what they say is, because Newey's use blind decoding, they will decode all the candidate channels, attempt to find one for them, and if they find one for them, they won't know the number of that channel compared to the number of all the other channels. But that's taking LTE as it currently is, and as it was developing, where there hadn't been put an index of the control channel in. So now we don't have an index of the control channel, because Panasonic's suggestion of CCE indexes has been adopted. And at the priority date, there wasn't an index of the control channel, but it's common ground, and Mr. Edwards, Apple's expert, agreed that it would be possible to index control channel. And we needn't go to the evidence, because my learned friend accepted yesterday that was the case. So it wouldn't be technically nonsense to do it, because it's accepted that it's something that would be possible. And consistent with that, in the 472 document, and maybe also in other documents that we might come to have a look at, nobody is saying, hang on, this is all technical nonsense, this can't be done. Now, what my learned friend does is she relies quite heavily on Mr. Bradford's evidence in cross-examination, and she says that shows that his view was that the Kobe agreement itself was ambiguous. And what I'd like to show, my lords, is just a few extracts of that to show you that that wasn't the thrust of his evidence. What his evidence was the skilled person would understand Kobe to mean that the channel will be indexed. What the skilled person wouldn't know was how that was going to be done, and the uncertainty related to the method as to how that was going to be done. So if we can turn to the supplemental bundle to tab 28, and we need to start with transcript page 263, which is on bundle page 324. And this is where Miss May, who was cross-examining Mr. Bradford, starts at line 15 when she takes him to paragraph 45 of his report. And then if we go over to page 264 at line 7, she says, Mr. Edwards says that there was no known index of the L1, L2 control channels at the priority date. And that's right, is it not? Yes, it was not clear how this would be done at all. And then she goes on to, Miss May goes on to mention that, put to the witness that one of the things he suggested as to how it might be done was to use the index of control channel candidates, which is one of the options that was discussed in the evidence. And then at line 23, she says, so you say in your evidence that you think it was likely that the skilled person would understand Kobe to be referring to the control channel candidates of this figure. And the witness says, I think the point I was making is it's just not clear what they meant at all. I think I made the point that it would assume that such a logical ordering of channels will be made clear in the future, such as this example being using the control channel candidates. I guess this goes to the point that I just don't think it's obvious that you would consider using the control channel elements to do this. So when he's saying it's not clear what they meant at all, he's talking about how they would index the channels. He says the skilled person would assume that a logical ordering of the channels would be made clear in the future. And then if we turn, then the cross-examination goes a bit more into the detail of the control channel elements example, which we can pass over. But if we go to the bottom of page 269 of the transcript, came back after the shorter Germans, and Miss May says, you seem to suggest this paragraph, the skilled person will understand the index of the control channel for scheduling that is referred to in Kobe as being the index of the control channel candidates. Is that what you're saying, or have I misunderstood? No, the point I was trying to get across, if they saw this diagram in D240 that was presented, and a reference here, the most likely conclusion they would come based on that diagram, I think what I say as a whole in my evidence is they would not really know what the index was, and it was not disclosed anywhere at the priority date. But my reference to this figure was one example of what they could think it would mean. So again, so the confusion as to precisely what the index is and how it would be implemented. And then down at 271, the witness says at line 6, Miss May asked at line 3, I was asking you to confirm that the technical evidence he gives that the effect of the control channel candidates is not the same as the control channel. And the witness says, with hindsight, we know that's not the case, but I don't think the skilled person would have appreciated that. Why not? Because there was nothing in the technical specifications or in the common general knowledge that explained how the control channels would be indexed or how this blind algorithm would be done. There's just no details on this at all. So there was a lot of confusion at this time on what control channel indexing meant. So again, the confusion related to what the precise index was. And then just the final bit of exchange on this, over to 274. At line 18, and this just again bearings at 272. Miss May's moved on to looking at the Panasonic 798 T-Doc. So we're in the context of this. So when she says at line 18, do you agree that neither the interpretations put forward in this Panasonic document, which was the two options, diplomatically phrased options, is consistent with what you say the skilled person will be likely to adopt, which is ACNAT resource linked to the control channel candidate? Answer, the first idea, how it is stated, the Kobe agreement, is the index of a layer 1, layer 2 control channel. What I was trying to get across is there's no agreed way of indexing a control channel. So I propose one way that maybe it could be understood as this DB10 is talking about another way. My whole point is just not clear what the index of the control channel is based on what was known at the priority date. So again, the point is, what was the index? But that was the extent of Mr. Bradford's evidence as to the lack of clarity. What he wasn't saying was absolutely no idea what Kobe meant at all, and whether it was completely ambiguous beyond any some kind of implicit signal. And what was never suggested to Mr. Bradford in any way, this passage, was that it couldn't be done. Indeed, he'd given an example as to how he thought the skilled person might have thought it could be done. So that's our answer to the first point, the technical nonsense points. The second point that my learned friend relies upon is the Panasonic 798 T-Dot, which we've just been mentioning, and that's in tab 18 of the supplemental bundle. So again, and I know I made this point yesterday, but I'm going to make it again. So Panasonic patentee of the patents that we are concerned with, and this is a document that was submitted after the Kobe meeting and a couple of months before the August 2007 priority date. And what they say is there could be two following different interpretations of the above agreements, having set out the agreements. Pros and cons of them are discussed. The first one is the ACNAT resources linked to the index of the Layer 1, Layer 2 control channel. And the pros are effective use of reserved uplink resources. The cons, additional signalling would be required for indexing the control channel if blind detection of the UE is a reasonable size. And then the second one, they link it to the control channel element. Pros, simple overhead, no additional overhead for signalling. And the cons, the reserved uplink ACNAT resources may not be, or the reserved uplink resources may not be used. And then they say, since adding the index of the L1, L2 control channel requires the same amount of overhead as explicit uplink resource allocation, we propose to clarify ACNAT resources linked to the index of the control channel element. Now, first point, of course, no suggestion in this document that using the index of a Layer 1, Layer 2 control channel itself is technically nonsense. We don't see anybody suggesting it's technically nonsense. But what the point they made is they'd appreciated that there was a downside of doing what had been agreed, and that's that you would have to add some signalling to do the index, and that takes away the benefit of doing it. And this document itself is accepted not to be common general knowledge. It was never advanced as such. It's a document that comes from the patentees themselves. And nor was there any evidence that the views expressed in this document, so the view that, well, if we use the Layer 1, Layer 2 control channel itself, we're going to have to add some more signalling overhead in, and that slightly defeated the purpose of using implicit signalling in the first place. So the concept and the reasoning not shown to be common knowledge. And Miss May never asked the question squarely of Mr. Bradford, and indeed, and I'll come on to what my learned friend said yesterday, but if we go back to tab 28 of this bundle and the cross-examination, the closest they got to it was page 273 of the transcript. And down at line 21, Miss May says, I'm not sure that's an answer to the question. Mr. Edwards gives evidence that a skilled person would understand the Kobe agreement as talking about ACNAT resources being linked to the index of the control channel elements. And all I'm putting to you is this document identifies that proposition as one of the two ways of reading the Kobe agreements. To that extent, at least, do you agree that's consistent with Mr. Edwards' views how the skilled person would understand Kobe? And the witness says, I agree it's in this document. I'm not sure the skilled person would read all the T-docs. I'm not sure the skilled person would know, unless the T-doc was part of their common general knowledge. I'm confused. So the witness making the point that if they hadn't seen this document, how would they know it? And my Lord Justice Arnold asked my learned friend yesterday whether Mr. Bradford accepted the technical considerations, the way my Lord puts it, in this document. And what my learned friend pointed the court to was that his evidence in one of his written reports that at the priority date there was no index of a layer 1, layer 2 control channel that had been specified. That's all that Apple point to. What they can't point to is any acceptance by any witness that it was widely understood that doing that would have the downside identified by Panasonic. And what Apple seek to do is to point to the 798 document and say, well, it says it there, therefore it must have been obvious that these were two alternative interpretations of Kobe. And as the judge said,
I'm a little puzzled by all of this argument because, at least at first blush, to my way of thinking at the moment, what seems to be rather relevant is what the witness says in answer to the question at 274 line 10. Because the question is, do you at least agree the second interpretation of Kobe as an obvious way for the skilled person, second interpretation of Kobe as presented in this document, i.e. Panasonic, is an obvious way for the skilled person to read that Kobe agreement? And the answer comes back very firmly, no, not at all. Well, that seems to me to be rather pertinent evidence.
yes, I mean, the witness...
I mean, insofar as it's a matter for experts at all. I mean, of course, if it's just a pure question of interpretation, then the evidence isn't admissible at all. But if we assume that it's admissible because the question is, well, this would be an obvious way to read it, i.e. you would think, the skilled person would think that, the answer given is no.
So there was evidence there for the judge as well as the supporting 472 document showing that that's what real people thought.
So why can we not say that the answer is simply as follows? First of all, insofar as it's a matter of interpretation of the document, the judge was right for the reasons he gave. Insofar as it's a question of what would the skilled person think, and therefore what would they do, answer, not obvious to interpret it to go in the second direction.
And the judge had evidence to support that before him.
Yeah. Why is that not the end of it?
Well, my lord, I mean, our submission that is, what I was going to do now, maybe I can short circuit this, was I was going to show you, I was going to deal with the points that my learned friend makes, that the judge had no basis to find that this document was a diplomatically phrased attempt to reopen the meaning, because she needs to do that, because she needs to rely upon this as showing that it was always had two meanings, and it always had the meaning she argued for. And one of the documents I was going to show you, which I can avoid doing, is the one that she took you to yesterday, which is the email exchange with the rapporteur, Stephen Parkville, which does come at the end of the chronology. But we say that document does support the conclusion. Well, I will do it, and I will do it as briefly as humanly possible. So I'll try and do this in chronological order. So could we get to tab 22 of the supplemental bundle? And this is a document from February 2007, so pre-Kobe. I think it's the meeting before Kobe. And this is a document from Qualcomm. And they say in this document we propose the following: implicit mapping between downlink virtual VRB, which is virtual resource block allocation, and uplink ACK ID as a baseline working assumption. And then if we go over the page, they say section 2.2, mapping of uplink ACK, And they give two options. One is implicit mapping from the downlink VRB. Now that's mapping from the actual block of data on the data channel that's sent. And in the next section, 2.2.2, they say implicit mapping from the downlink PDCCH. This is the one to focus on. And the document says in this structure, there's an implicit one-to-one mapping from the downlink PDCCH index to the uplink ACK location in frequency and time varying cyclic shift. So that is a reference to the downlink index. And I asked Mr. Edwards about this in cross-examination. So if my lords keep your fingers in that and go to tab 30 and page 630 of the transcript, which is 391 of the bundle. And the cross-examination starts right at the bottom where I take, at line 23, where I take the witness to this document. But the bit I would like to show your lordships is the top of 633. And I say, but if we look at what they're envisaging, to answer my question, they're envisaging a one-to-one mapping from the downlink control channel index to the uplink resource. In that particular section, they're also envisaging a number of other ideas. They're not envisaging the CCEs playing a role, not in that one idea, no. So a clear acceptance that this proposal was implicit mapping to the index of the channel and not the CCEs, and also obviously the document is proposing it and not suggesting that it's technically nonsense. So then if we go to tab 16, and as we can see from the front sheet, this was an exhibit that Mr. Edwards himself had put in. And this was a proposal put into the Kobe meeting, so at the same, obviously slightly in advance of the meeting, that the decision was made. And it's made by multiple companies, NTT, Fujitsu and Mitsubishi. And we see in the second section, basic approach to implicit resource allocation. And they've got two alternatives, which are the same as in the one we've just seen. Use an implicit relation between the downlink resources used for data transmission and the uplink resource. An alternative to use an implicit relation between the downlink control channel used for assignment of the downlink shared data and the uplink resource. And if we go then over the page 2 of 3, just below the 4 bullets, we say our proposed method establishes a predetermined relationship between the downlink layer 1 layer 2 control index, which is used for some UEs, and the procedure is given as follows. And then 4 lines up from the bottom of that paragraph, assuming that the index of the downlink layer 1 layer 2 channel, the UEs, is P is a natural number, then the index of the Kazakh sequence, the index of the frequency, the index of the orthogonal sequence are determined as follows. And there's then some maths. So again, we say clear that the proposal being put into the Kobe meeting itself is that it's the channel itself, and indeed it makes it clear that the channel has a number P. And again, I put this to Mr. Edwards. So if we flick back to tab 30, and this was a slightly earlier passage of cross-examination, and if we go it starts at 623, just so my lords can see I'm actually running on the right document. So 623, line 15, go to D2 tab 29, that's the document we were looking at. And I took him through the disclosure, and then at 626, line 17, I say, sure, absolutely, I understand. All I am focusing on is they're envisaging what they call alternative 2 will be implemented. Let me put this to you again, that these authors are assuming the downlink layer 1 layer 2 control channel would have an index. I think that is correct. Now, he did go on after that to start talking about CCE index again. but it's clear that he accepted that the authors of the document were talking about the index of the channel itself, and we saw that from the documents. Then in the chronology, then we have the 472 document that we've already looked at, which again makes it clear that the proposal is the index of the channel, and that multiple participants have decided that was the way to go. Then shortly before the priority date, the Panasonic 798 document that Learn a Friend relies upon comes along. And what we say is, given that everyone's up to this stage had been looking at index of the channel itself, when the judge then looks at 798 in context, you can see that it does mark a change of direction. And there's been, and Panasonic have put that change of direction forward. They've phrased it as they've phrased it, but it does mark a point of inflection. And that's then consistent with the email chain, which comes shortly after the priority date that my learned friend showed you yesterday that we don't need to go to, where the rapporteur is suggesting that using the CCE index is an alternative to using the channel index. So we say that the judge was right to come to the conclusion he did in relation to the 798 documents. The document itself is not common general knowledge. Contents of it are not shown to be common general knowledge. Contents of it constitute a change in the thinking within Randall. And so we think of my Lord Justice Birss's categories of lack of clarity that you gave yesterday. There was this statement is clear, but it's very silly, which is the moon is made of blue cheese. And this is not that case. There's an interpretation where there's a potentially silly interpretation or a sensible interpretation, and one may say, well, actually, one construes it to mean the sensible thing because that's what they must mean. But this is a slightly different example, we say. This is something that is, as originally agreed and recorded in the Kobe meeting, whether one calls it silly going too high, but it has a drawback. But it has a drawback that was only perceived after the event. So it's something that appeared sensible at the time, but with more thought became apparent to those, firstly to Panasonic, the patentee, and later to the rest of the RAND group, that actually it had some drawbacks. And so what my learner friend can't do is look at the document, not common general knowledge, shortly before the priority date, where that realization dawned on Panasonic, and say that must mean that it was always apparent to everybody that this was silly and it was technically nonsense. So that was all I wanted to say on Kobe, unless there are any questions on that. I wanted to move on to construction of 810 now. And like my learned friends, we can look at the passages of the patents from the 549 patents because they are the same. And the judge dealt with this at paragraph 254 of the judgments. We'll start at 254. And so my lords obviously have the rival contentions. The way the judge construed the claim was the judge construed the claim in the 810 patents as requiring that it's the CCE, the CCE number in particular, we'll come to that point in a moment, is the one that is mapped to the uplink push resource and determines the resource that the UEs use to transmit. My learned friend's case that the judge dealt with and rejected was that it was wider than that, and it also covers using the index of the layer 1, layer 2 control channel. And the judge rejected that for essentially 3 reasons. The first one is the passages of the specification. And if we can just look at those passages, so that would be Supplemental Bundle tab 1. And if we go in that to paragraph 21 in column 6. So starting first with the paragraphs that the judge refers to in the specific embodiments. And paragraph 21 starts talking about, in the following description, the cases describe where there's a ZC sequence of 12 and a Walsh sequence length 3 is used, not limited to those. It gives some description of the numbering of the ZC sequences. And then in 23, in the following description, is assumed that layer 1, layer 2 control channel number 1 occupies CCE1 and so on. And in the following description, it's assumed that a CCE number and a push number defined by a ZC sequence, cyclic shift and Walsh sequence number are mapped on a one-to-one basis. That is to say, it's assumed CCE1 and push number 1 and so on are mutually mapped. And so clear teaching there in that paragraph that what are linked and what are mapped is it's CCE to push, and it's not layer 1, layer 2 control channel to push, notwithstanding the point that counsel always make when one's trying to construe a claim that the patentee is clearly aware of layer 1, layer 2 control channels and have just mentioned them. They specifically link the mapping to the CCEs and the push. And the same, we see the same thing throughout the whole of the teaching of the specification, and the judge also highlighted paragraphs 49 and 56 to 59, all of which is the same effect. And then if we go, so those are all in the specific embodiment. And as the judge said, one can only take that so far, and I accept that. Optis takes that on the chin. But what you don't see anywhere in the specification is any support for indexing anywhere by any other means. And in particular, there's no suggestion of indexing by the index of the layer 1, layer 2 control channel. So it's supportive of our case, and there's nothing in the specification that supports Apple's case. There's then a similar teaching in paragraph 11, and goes back to that at the bottom of column 3, which starts off by talking about the Nokia prior art, but then segues into talking about figure 6, the mesh structure of the patents, and again, at the bottom of the page, it's assumed that CC number 1 and push number 1 and so on and so forth are mutually mapped. So reinforcing in the general part of the teaching the mapping between CCEs and push resources. And again, supportive of our case and nothing to support Apple's case. And then the final bit that the judge referred to was Mr. Edwards's evidence. And my little friend took you to some of that yesterday. First of all, supplemental bundle tab 9, paragraph 193. And this is Mr. Edwards' first report, so this isn't evidence that was extracted under heavy cross-examination. This was volunteered first time out, and he says that the reference to CCE numbers is explained in paragraph 11. As discussed in paragraph 4, the patent assumes there will be a unique mapping between CCE numbers and push numbers, where the push corresponds. And then he then goes on to say the skilled person would understand this to be referring to the agreement reached in round 1, that the resource will be linked to the index. Now, what my learned friend said yesterday, what she submitted yesterday, was, well, this doesn't help Optis, because it's clear that Mr. Edwards arrived at his conclusion based on his misunderstanding of the common general knowledge about what Kobe meant. But that's not what this paragraph says. The paragraph starts off by Mr. Edwards explaining what he understands the document to be teaching. And then he says, the school person would go, oh, I understand that because that's what I know Kobe meant. He doesn't say, what this paragraph doesn't say is the skilled person would read it the way he reads it in the first sentence, the second sentence, because of their understanding of what Kobe meant. I then took Mr. Edwards, I perhaps slightly foolishly asked him to confirm this in cross-examination. We can see what that passage, that's in tab 29 of the bundle. And it's page 523 of the transcript. And it's down the bottom, line 21. Could you go back to your first report to paragraph 193? Here you're referring to paragraph 11. You say, as discussed, the patent assumes there'll be a unique mapping. We don't need to go through it all, but that's right, is it not? The only way the patent describes the UE determining the push resource is looking at the CCE number. Yes, I believe that's correct. It's in the background art when it's talking about in order to use, yes. We both know which paragraph, yes, that is correct. Now, the point my learned friend made was that I then, I think we then looked at some of the later passages in paragraph 23 and in the specific embodiment. And the submission she made to your lordship yesterday was the entire cross-examination was based on the specific embodiments. Well, it wasn't. We started off with paragraph 11, and we then moved on to specific embodiments. But even though some of the cross-examination was specific embodiments, we say that doesn't detract from the evidence that the witness gave, that the only thing the patent teaches is linking between CCE, index, and push, not layer 1, layer 2 control channel, index, and push. So, in relation to the teaching of the specification, we say it's all consistent with Optis's case and inconsistent with Apple's case. Her second reason is, and the judge's second reason is Kobe. In 263 of the judgment, the judge says Kobe's relevant. I've concluded that it was CGK, that it was a specific effect that the control channel index would be used for implicit signaling. This helps Optis. The reader would have the impression that the patentee was proposing a different approach. And we say that's correct. But of course, my learned friend challenges the judge's interpretation of Kobe and says that the skilled person would think that it was ambiguous and that also use of the control channel index was technical nonsense. And what she doesn't explain is why a skilled person of that mindset would think this patent that doesn't refer to in any way indexing by control channel index to push would think that something they thought was technically nonsense and wasn't mentioned was in fact being referred to in the claims by an association with CCE index. So when one understands Kobe correctly as the judge had done, he's right that it's supportive of the construction he's come to, that the claim is limited to indexing by CCE number to push resource. But as soon as you go to Apple's interpretation of Kobe, one has to ask the question, well, why does a skilled person who thinks something's technically nonsense read the claim as including it when the patent doesn't tell them the way to deal with what they previously thought was technical nonsense? So either way, the common general knowledge of Kobe doesn't help. And the judge's third point was the wording of the claim, which we say he was right in relation to. The patents chose to use CCE, not Layer 1, Layer 2. And what Apple has to do is to say, well, the claim uses the word association rather than mapping. That's wider language, and therefore it must include the Layer 1, Layer 2 control channels, because the Layer 1, Layer 2 the CCEs make up the control channels. And this is where the diagram in 265, and which I cross-examined Mr. Edwards on, is relevant, because as the judge points out, depending on the aggregation level of the CCEs, different CCEs are form or are part of different control channels. So there is no necessary association between a particular CCE and a particular control channel. And I put all this to Mr. Edwards, and he accepted that was correct, and the judge accepted it as well, and we say that's plainly right. As the judge records in 266, there was then a further argument that the 267, sorry, that the feature includes the use of downlink control channels simply because the downlink control channels are made up of CCEs. And we've been trying to think of an analogy for this, and I'll try this one, and I know my lords will probably give me the same answer that I've had for all my other analogies. But my learned junior has a friend who she's associated with. I'm using her because it's her example. So she's associated with her friend. Her friend is a keen cricketer and is a member of the MCC, and therefore her friend is associated with Lord's cricket ground. But if Miss Dixon turned up at Lord's and said, I've got a friend who's associated with you and I'm associated with them, can I come in? She's likely to get pretty short shrift. And slightly silly example, but what it shows is just because one thing is associated with another thing, and that other thing is associated with a third thing, doesn't mean the first thing is associated with the third thing. It's a logical fallacy. And what the judge's illustration in the figure above 266 show is that in this case, even though you could have the CCE being associated with the uplink control channel, there's no necessary association between the downlink control channel and push. Different channels will contain different CCEs and therefore have different resources. So there's then a point taken that the claim doesn't refer to the linking being by the CCE number. And there are two answers to that. Firstly, that there's nothing, and certainly nothing that the patent discloses about CCEs other than their number, that is capable of linking from the CCE to the push resource. The patent specification refers to CCE number 1, 2, 3, and so on. And in context, we say the claim would be understood to mean CCE number because there's nothing else about a CCE that enables it to be identified with an uplink resource other than its number. And the second one is my Lord Justice Birss's point from yesterday, that if there's aggregation, which the patent clearly contemplates, there will be multiple CCEs going to a particular UE, and you have to have a claim, you have to be able to decide the uplink resource from one of them. And my learned friend's immediate response to that was, well, then it should have said the lowest one, but of course that would be a claim that would be almost worthless, because then an infringer could just link to the second one, the third one. So what the patentees have done is they've, by use of CCE generally, they've catered for a situation where a downlink channel on the PDCCH is either one CCE or is multiple CCEs. And we say overall stepping stepping back, there's simply nothing in the specification of the patent that suggests that the patentees were intending to have the mapping between downlink allocation resource and uplink touch resource done via anything other than the CCEs. That's all there is. And so in context, the word association, we say, would be understood, as the judge held, to mean mapping. Which then brings me on to the final topic, which is obviousness. And as I said at the outset on 810, Apple's skeleton proceeds on the basis that if they succeeded on novelty over Nokia, they've overturned the findings on Kobe, and they've persuaded your lordship to change the construction of 810, then EP 810 must be obvious. And the way they do that is they say, well, there were three possible interpretations of Kobe that were discussed at trial. There was control channel elements index, index of the control channel, or index of the control channel candidates. Those were the three that were discussed in the evidence, and that's right. And they say, well, the last one of those, index of the control channel candidates, the judge found that to be unattractive, so we can forget about that one. The implication in the submission being, because it's unattractive, it wouldn't be thought to be an obvious way to go. So says the argument, that leaves you with two possible interpretations, CCE elements index and index of the control channel, and if they both fall within the claim, hey presto, they're both obvious. But that is a backwards way of looking at the question of obviousness. And what it hides is, because if one follows the logic of the submission, it ought to be the case that the use of a CCE index was obvious. But the judge expressly considered that and expressly rejected that argument and held that it wasn't. And that's the judge's conclusions in paragraphs 407 to 409 of the judgment. Where he looked at the, what he refers to in those paragraphs is the bit of cross-examination and that diagram that I took you to for a slightly different purpose. It was deployed to show that application of CCE index in the context of Nokia would be extremely unattractive because it would show adjacencies accumulating quickly. And as the judge says in 409, it was another example of Apple's case being presented in an abstract way and failing to cope with the detail that necessarily followed. So, judge rejected on the facts obviousness of using CCE index. And that's just an illustration of why you can't say, well, there was an option for the interpretation of what Kobe meant, and therefore it would have been obvious to do it, because the judge found expressly that it wasn't. And we don't understand there to be any challenge to the finding of non-obvious of using CCE index. What's said is the third alternative, index of the control channel, that would have been. Now, we've got 2 points on this. Firstly, the more detailed one, and then a more general one. The more detailed one is that at this stage of the argument, we have to orientate ourselves properly. We're assuming that Apple has persuaded you that the judge was wrong on Kobe, because that's a key part of their way into construction, and also obviously that they've succeeded on construction. So we're on the assumption that Kobe would be understood as suggesting, not to be understood as suggesting any method, just a non-specific implicit signaling, and also on the basis that the skilled person thinks that the index of a control channel is technical nonsense. That was a key part of overturning the Kobe, judge's construction of Kobe. But if that's the case, what Apple doesn't do is address why something that, on the assumptions where we've got to in the argument, is technical nonsense, would nevertheless be an obvious thing to go and do. And And the contrast with the dismissal of control channel candidates as being obvious because it was unattractive, we say the same logic ought to apply on the argument as to where we've got to the index of a control channel. Now, of course, if my lords haven't agreed that it's technical nonsense and haven't changed the judge's construction on Kobe, then that kicks away the legs of the argument and the way into the construction of 810, and we never get to ask the question in the first place. And what they're trying to do is partition up the arguments, say it's technical nonsense to use the index of control channel in order to get to where they want to on construction, and you forget about that, and then say, but it's the obvious thing to do. That's the specific point in relation to this. The more general one is even if somehow Apple persuades your lordships that to alter the judge's construction, to widen it to include index of the control channel itself, without any alteration of the judge's conclusions on Kobe. I don't understand that being advanced, but it is at least a conceivable outcome. It's still the case that a party seeking to revoke a patent needs evidence to show why it says something was obvious, why it was. And obviousness obviously includes a reason to want to take a step and an obvious way to do it, a means to do it. Now, as I've explained, Mr. Edwards addressed 810 solely on the basis that Kobe meant CCEs. So if I can just show you a passage from one paragraph from each of his first two reports. So that's Supplemental Bundle tab 9, first of all, and paragraph 384 on page 202. So this is where Mr. Edwards comes. So bundle page 202, paragraph 384. So this is where he comes to deal with the claims of the 810 patents in the context of Nokia. And in 384 he says, would know as part of their CGK it had been agreed, he sets out Kobe, also something Nokia discloses, would have the meaning I explain at 159 above, and that's CCE in element index. And he explains how that will be done. So and that's the only evidence he has on chief on that issue. And importantly, in the next tab, in reply, on page 227 of 227 of the bundle, so in paragraph 92, he says, at para 60 and 62 above, and in my first report, the paragraphs we've looked at, set out my view that the Round 1 agreement would be understood as requiring association in the mobile between downlink CCEs and the push resource, even though the index of the control channel might not be understood to mean precisely the same thing as CCEs. I consider the skilled person would have thought associating the resource as the obvious way to proceed. Mr. Bradford states, Nokia doesn't explain what the index of the control channel means. However, the skilled person may have assumed that as the standards develop, logical ordering would be developed. And that was the point he repeated in cross-examination. As I've said, I agree the priority date and index was not known. I consider that it would be obvious to implement the RAN 1 agreement by associating ACNAC resource to the received CCEs, rather than assuming a new index of PDCCHs would be developed for this purpose. So what the witness is saying there is he thinks the obvious thing to do is to use CCE index, and it is not obvious to use the index of the PDCCHs themselves. So that was Mr. Edwards' evidence. So that doesn't help my learned friend at this stage of her case. We've seen earlier today Mr. Bradford's evidence in cross-examination that he thought he understood it to mean the index. He said the skilled person would assume that would have to be developed, but it was unclear as to how that would be done. So the means of achieving the indexing, his evidence was, a skilled person would be unclear as to what that was. And what Miss May, who was cross-examining, never did, was put to Mr. Bradford any way that Apple contended it would have been obvious to do, to index the control channels themselves. And of course that would have been an essential part of an obviousness case, because merely saying, well, something might have to happen, doesn't mean it's obvious as to how it can be made to happen. And she didn't do so. She cross-examined primarily on Kobe via the Panasonic 798 documents, and she focused on the second option of CCEs, and never put to Mr. Bradford the line of cross-examination that my Lord Justice Arnold hypothesised yesterday, which is, now, let's assume that it in fact means layer 1, layer 2, control channel index. This is something that could be done.
Or even assuming it's ambiguous, then it's obvious.
Yeah. And it wasn't put. The focus at trial was on CCE index, because that was Mr. Edwards' view as to what it meant. And so there was a slight shift to ambiguity as the case went on. But the case wasn't properly put, and there is simply no evidence as to an obvious way in which the channels themselves could have been indexed. And so my learned friend is inviting the court to overturn the construction and to then substitute the finding of non-obviousness with the finding of obviousness. But that requires her to be able to point to some evidence to support it, and there simply isn't any. Unless my lord's got any other questions, those are my submissions.
Thank you very much, Mr. Hinchliffe. Miss Lee.
I'll just set myself up if that's okay. So I'm going to adopt the same order as my learned friend and start obviously with construction and just pick up a few points in that topic first of all. The first one relates to the fact that my learned friend says that the skilled person would know that the phone could only do ACNAC or CQI, and so would therefore understand that use in the claim, and in particular in the characterising portion, doesn't mean actual use, because a single phone can't send ACNAC and CQI at the same time. And we say in response to that, that the claim language makes clear that they're not sent at the same time by the same phone. And so my learned friend's attempt to answer my point about use isn't a good one. And we can see that if we look at the language of the claim. I'm taking it from, as previously, the core bundle 105 that my lord may be following in the supplemental bundle. And it's just a case of looking at the wording of integers 1i and 1j, which is the same in each case. And so 1i says, characterising that said first spreading unit in each symbol that forms the ACNAC signal uses said code multiplexing cyclic shift value. And so in other words, the phone is only doing this if it's in the symbol that forms the ACNAC signal. And that makes clear, therefore, that if it's in that symbol, it's doing that. And so it wouldn't also be in the other symbol that is using or doing the CQI signal. And so we say the wording of the claim, because that's clear from integer 1j, which has the same wording. And so we say effectively that the wording of the claim takes care of this point that my learned friend has made. And so it doesn't detract from our case, which is uses has meaning and is obviously different from the adapted to part of the claim in the earlier integers. So then we've got next point, the two-part claim point, and question is whether the skilled person reading the claim attaches significance to the fact that the adapted to wording is only in the pre-characterising portion and the used wording is in the characterising portion. And my learned friend's attempted answer to that was, well, actually, because the EPO guidelines say you don't have to use a two-part claim, then it can't be used as a guide to construction of the claim. We say, well, it's still a factor that can be taken into account and would be taken into account by the skilled person. And the fact that the claim has been amended doesn't change that. The patentee wasn't somehow forced to do it in a certain way because of the amendment, because in fact the claim as unamended still used adapted in the pre-characterising portion and uses it in the characterising portion. So although the first adapted wasn't there in 1A, we still had adapted in 1B, C, and I think H also has an adapted in it in the unamended claim, and then uses also appeared in the unamended claim characterising portion at 1I and 1J. And we don't just, as my lords will appreciate, rely on the pre-characterising portion and the characterising portion. We also rely on the description and what that informs the skilled reader of. And in particular, my lords will recall, and I don't think I need to turn up, the fact that in the early paragraphs of the patent, I think it's paragraph 5 and paragraph 7, it's explained that in LTE the ACNAC signal is spread with a Zadov-Chu sequence and then with an orthogonal sequence, and that you spread the CQI signal with a Zadov-Chu sequence. And that, of course, reinforces the skilled person's understanding that the pre-characterising portion, which discusses those things, is not inventive. And that's without even getting to the, well, allegedly controversial labelling of Figure 6 and Figure 7 as conventional. Next, we have my learned friend's attempt to answer my paragraph 63 and 69 points. And my learned friend said that these paragraphs only make sense if the mobile has all the code in it to deal with each of the 3 code multiplexing structures, by which he meant the 2 alternative versions that fall within the claim, and also that third embodiment that falls outside the claim. And we say that's not correct, because those paragraphs would still make sense if the phone did not have all the code in it, but was in each case just sent detailed instructions about what to do by the base station. So in other words, my learned friend can't get out of this point on paragraph 63 and 69 by saying that's okay, the skilled reader would know that it's all the code is in the mobile. So it doesn't detract from our point that the patent is telling the reader that the difference lies in what the base station is doing. And so as I made clear, that means we say that the implication is that the difference only arises when the code multiplexing structure is actually in use. Next, a short point about conventional case 1. The issue has been raised that it says conventional case 1 twice, and we say that's not a reason for the skilled person to conclude that conventional is a mistake, because it's much more likely that they'll think that the second one should have said conventional case 2. It's perhaps a trivial point, but in my submission, the skilled reader sees 2 references to conventional, and the fact that they've been numbered the same doesn't make them think, the reference to conventional must be wrong. Now, my learned friend then has a series of, I suppose, appeals to the heart, or if I can put it like that, which is these types of claims are allowed, and they ought to be allowed and therefore there's nothing wrong with this, and you're being terribly unfair to us by saying, oh, look at the wording of the claim, it says uses, when everyone knows adapted is completely fine and dandy. And we say, and he refers to co-flexip, and we say, well, obviously, each case has to be decided on its own facts and in particular, on the wording of the claim in question. He also says, your approach makes things terribly complicated because you can normally tell whether or not something is infringing just by looking at the product. If only life were so simple, my lords. Because the reality is, with this type of claim, that is not possible. And we know that from Philips and Nintendo and IP, Vodafone, and the time that we've spent, obviously, in this court. So that is not an answer. He also says, a phone sitting in a box would not infringe even if LTE used mixed resource blocks in the United Kingdom. And he says that would be an outrage. And we say, well, that's wrong, because it would be a threat to infringe if mixed resource blocks were consistently used in the United Kingdom, and it would infringe section 62 as well. He also has his point that it would infringe in France, but not in the United Kingdom, and he says there's something very odd about that because it's the same LTE standard in both countries. And we say there's nothing odd about the fact that wouldn't be infringement in the United Kingdom when no one ever uses or takes the benefit of the invention in the United Kingdom. So moving on to adapted to, and we then have obviously the textual analysis of IPCOM and Vodafone, which I enter upon with some trepidation, knowing that obviously my Lord Justice Arnold knows a great deal about this case, but nevertheless it's got to be done.
Before you do, I mean, you're quite right, of course, Ms. Lane, it's got to be done, and I'm sure it will, and that's fine. Just before you do that,
yes,
something you said a minute ago just resonated. I mean, this is ultimately all about construction, isn't it? This isn't about the law of infringement. It's about construction.
well, my first point is all about construction, yes.
No, but this too. This is all about. There's nothing else. Why is this not just a point of construction?
Well, because I suppose it could be looked at as two alternative constructions, and my first construction is it's got to be in use, and my second construction is to do with the meaning of adapted to.
Right. Yeah.
Yes. So that's. But I suppose in my own head I've been thinking construction point one, second point. What's the law in relation to the meaning of adapted to? Because we are not trying to say
it's
adapted.
conventional language, and I'm not
Yes,
trying to suggest
my
you
Lord
shouldn't
is
look
absolutely
at
right,
the authority,
yes.
but it is ultimately a question of construction.
Yes, that's correct. Yes, and so it probably is worth turning up IP and Vodafone, IPCOM and Vodafone again. I'm certainly going to have it in front of me, and in particular because I want to discuss what my learned friend said about what the ratio of the case is. As I say, entering into this with some trepidation, but I will put my points. So my learned friend reads paragraph 117 and says, well, the ratio of this is the bit towards the end of the paragraph that says, I do not accept counsel for IPCOM's submission that this is analogous to a radio which has a switch to change from mono non-infringing to stereo infringing, because in that scenario there'd be infringing circuitry present at all times, even if it was not in operation at any particular time. And we say, well, clearly what's happening there is an analogy is being made between the facts in IPCOM and Vodafone and this scenario where you've got a radio which has mono and stereo circuitry in it. And so we say that's discussion of that analogy rather than being the ratio of the case. And one reason for that, quite apart from the fact that it's talking about an analogy, is because the test, which my learned friend then says is the upshot of this, is does it contain infringing circuitry? And we say that can't possibly be a general test in this type of case, because of course a general purpose computer has the same circuitry regardless of how you program it. Now, my learned friend was then asked whether, as a result of that submission, he was then just limiting the test effectively to reprogramming, and whether reconfiguration or changing the settings, in other words, doesn't add anything. And he said, no, it has to be able to do it, i.e. the apparatus has to be able to do it. And we say that that's an acceptance that reprogramming is too limited. And we also say it's clear from this judgment itself in IP, Vodafone, that the test must be wider than reprogramming, because the Court of Appeal held that there was no reprogramming, just changing the settings. And that can be seen from the end of paragraph 116 and the beginning of paragraph 117, which we've already gone through. And so we stick to our guns and say that the final part of paragraph 117 is the ratio of this and the test being set out, which is whether it's appropriately programmed or adapted or configured to send barring parameters. And we say that is the correct approach. And of course, if the test is whether the apparatus is able to do it, which is what my learned friend said, then the LTE mobile isn't able to do this thing without various parameters being signalled to it. So we say that test in any event wouldn't get my learned friend anywhere. The other thing my learned friend said is that no one is changing the article alleged to infringe in this case. He said, well, in IP, Vodafone, the base station was being changed somehow, and here the phone is still an identical piece of equipment. We say, actually, that's simply wrong. I mean, the base station was still the same piece of equipment in IP, Vodafone, just as the phone is the same piece of equipment here. And what is being done is that different signalling is being sent, or different commands are being sent, and that is what causes it to act differently in each case. In each case, there has to be some kind of external intervention. Now, my learned friend, interestingly, didn't actually take my lords really to the judge's judgment on this point and try and support it. And we say that's because it's certainly wrong if you say that the ratio of the case is of IP, Vodafone is programmed or adapted or configured. And it's also wrong if you say that it's to do with whether it contains the infringing circuitry. So on any view, the judgment in this case doesn't apply the correct test, and so my lords must approach this point afresh. Now, my Lord Justice Arnold said, what's the underlying principle? An excellent question. And said it's relevant to ask, should it be infringed? It's also relevant to ask, is it a non-infringing device from a common sense point of view? And we say, from a common sense point of view, as I think I've made clear, it's very odd to say that this is an infringing device in circumstances where it never takes the benefit of the invention or does the things that the patent talks about. And it is not possible.
You say that in the case of any optional requirement in a standard.
But
that's effectively what this is. I mean, this is an optional requirement in the standard, but you have to provide the logic in order to comply with the standard if that option is used. And in some countries it's used, and in other countries it isn't used. But you have the logic, and therefore why don't you infringe?
But it is effectively disabled in this country. I mean, it doesn't happen, and
It
there's
isn't
no
disabled. You could do it overnight in this country. And if instead of sending a 0 to Apple's phones in this country, a 1 was sent, lo and behold, the invention would be operating and used.
Well, one is always tempted to go back to the facts and say you could do it overnight in Vodafone as well, and also to say, well, actually, on the basis of the evidence that I showed my lord the other day, it's not a question of doing it overnight, because it all depends on whether you've got these narrow bandwidths, and those are all decisions that are taken at a high level about what the bandwidths are that are available.
Do you need to have, I mean, I follow that the thing is useful if you've got the narrow bandwidth, but do you need to have the narrow bandwidth to operate this scheme? You probably don't, do you?
I don't think you need to, but you just would never do it.
You wouldn't do it.
Yes, yes.
Zane, if I were running a travel agent's business, which sometimes is much more attractive,
I couldn't agree more, my lord.
and I decided to start selling translation phrase books for my customers to use when they went abroad.
Yes.
Now, they might use them also to listen to radio from France, let's say, but I would be selling them something in this country, which they might not really find much use in this country, or might never use in this country. But its economic significance as an item of commerce in this country is because people will go abroad and expect to be able to use it when they're abroad. I'm not suggesting it's a perfect analogy, but doesn't it show that the fact that a phone will be something which will be used, will work wherever you go, is of some significance, even when you're selling it in this country, and even if you're not going to use it in this country.
But my lord, export isn't an act of infringement.
I'm not talking about export. I'm talking about buying something in this country which I want to be able to use when I travel.
But it's not. It can't be used in this country at all. It's disabled. I mean,
Yes.
it's effectively unusable in this country.
Yes.
And so.
But I know it is. Well, I'll take that. I mean, but if your clients could sell a phone which said, and by the way, don't take this to France. It will not work. And I appreciate France is probably a bad example, because maybe it will work in France. But you could be selling phones in which you hard disabled this facility from the telephones for sale in this country, so that but you'd have a lot of rather unhappy customers, I rather think, because people do in fact take advantage of the roaming facility of phones. And in fact, it's a key reason why we have these standards at all, is precisely in order that you can go in other countries and not worry about the fact that you just switch it on and off it goes.
Well, the more pertinent matter is that perhaps that my client and mobile phone operators in general can't avoid having the functionality in the phone, because this is a set. Because this is a set case.
Yes.
We know they've got to have it.
Exactly.
And
And therefore you do have it.
Yes. Well, actually, that's not even right. You could sell a phone that's non-compliant. You just have to say it was non-compliant. You could say this is not a compliant phone. It'll be cheaper. We'll charge you £10 less for a non-compliant phone which doesn't work in countries in which mixed resource blocks are available. And we'll even help you by publishing on our website which countries they are.
But we say whether or not this is useful ought to be recognised in determining whether or not there is infringement on a common sense point of view. I mean, if we're talking about common sense, the fact that this is never used in the UK is something which is relevant and should be relevant to whether there or not there's infringement in this country.
Okay.
So, my lord, I was planning to move on to the Nokia anticipation next. And there's a few points that I want to tackle here. First of all, my learned friend's point that the code multiplexing structure is the whole thing, the complete map of what to do and not to do. And in particular, he raised the fact that I didn't discuss with my lords yesterday, paragraph 245(2) of the judgment. And the last line really is the critical one. The grids and the figures are complete maps of what to do and not to do. And we say that the reason, that this sentence has to be read in the context of the judgment as a whole, and the judge must mean here that a code multiplexing structure is a complete map during a particular period in time. And the reason that it must mean that is because otherwise the problem would be that the standard has plenty of rules in it which would allow totally different code multiplexing structures. So I think I went to it previously, but in the core bundle at tab 20, page 340, you have figure 8, and on the left-hand side, you have got one of the LTE, something from the LTE standard.
Sorry, I haven't kept up with you. Which page are you on?
Sorry, tab 20,
Oh,
page
I'm in the wrong
340.
bundle, I think.
Core bundle, yes.
Account for it. Yeah.
And so we must be looking at this in a particular period of time, we say. And that must be what the judge means, because otherwise there would be a problem on infringement. And so what that means when we come to Nokia is that you are looking at a particular period of time, and you are also, of course, looking at it from the perspective of what the phone is adapted to do. And if it is only one of 18 UEs at the particular period in time, it's plainly adapted to leave gaps. And we say that this is also reinforced by the fact that when you look at Nokia, Nokia clearly sees the benefit of filling up the grid in a certain way. I mean, it isn't just filling up the grid in order 1, 2, 3, 4, 5, etc., all the way up to 36 or 35. It is leaving between the first 18 a cyclic shift difference of 2, and that is why we say table A and table B can't sensibly be thought of as being the same code multiplexing structure, even though they're both completely filled up. And that would be the logic of, or the ultimate logic of my learned friend's submission, that basically all you see in Nokia is the fact that all the squares are completed.
Can you remember where table A and B are? I know what you're talking about.
Yes.
I can't remember where to find
Well,
them.
one place to find them is in Nokia itself, which is supplemental bundle tab 5, page 89.
Okay.
They're also in the judgment. I can't, off the top of my head, remember the paragraph number.
369, isn't it?
Yes, that sounds right.
So your point is that A and B, which are the left-hand two in the Nokia,
Yeah.
page 89, you say that your point is that those are different code
Yes.
multiplexing
Yeah,
structures.
even though they're both completely full.
Yes,
Whereas on what my learned friend says is, oh no, they're all full, and therefore they basically must be the same thing because they're all filled up. Because they use all the resources.
The fact they both use all the resources doesn't mean they're the same thing necessarily, but I understand the point you're making. And the difference between them is the order in which these blocks are filled.
Yes, exactly. And they have, A and B have different cyclic shift intervals, and they do that for a reason. And the reason, as my learned friend explained, is that Nokia allows the base station to make a trade-off between the capacity of the cell and interference. And certainly for the first 18 UEs in table B, it's making that trade-off by having a 2 cyclic shift mesh, and in table A, it's doing it by having a 3 cyclic shift mesh. And so those are two different things. That means, since the point of Nokia is to allow this trade-off to be made, that the base station can decide that there should be a maximum of 18 UEs. And in that situation, we say that you have the code multiplexing structure of the claim, and certainly you have a mobile which is adapted to operate with the code multiplexing structure of the claim.
In the standard, or maybe here, would you expect the cell to change these parameters midstream? Would you have, is what this really, because these are broadcast, aren't they? So these are essentially the parameters of a cell. You get to a cell in a certain bandwidth, and these parameters are what you'd expect to be applicable for while your phone is in that cell.
I'm not sure about the answer to that. Can I check with my learned junior in case he remembers? I'm told that it's not the same in the cell for all time, but they don't vary rapidly.
Okay.
Does that answer my Lord's
thank
question? We've then got the fourth column point, if I can put it like that. And my learned friend says, oh, well, you've got a problem because there's a fourth column here and it's used for periodic ACNACs. And we say, well, the fourth column is obviously, if it is used for periodic ACNACs, then they are not going to be occurring all the time. And so certainly some of the time it would be empty. And clearly when it is empty, you do have the code multiplexing structure of the claim, and certainly the mobile of Nokia is adapted to have that code multiplexing structure. Then we have my learned friend's point about the illustration in the judgment at paragraph 408, and I better just get that in front of me. Ah, yes, that's right. So CCEs, he says, well, that shows you that what's going on in Nokia is different because it would fill up the could fill up the resources like this, and then you would get an adjacency here in the example if you're using CCEs, and that's what that cross-examination was about. But in fact, it's clear from Nokia itself, and I think we probably need to turn it up, I certainly do anyway, that in Nokia you use the control channel index, and that is what it says on page 1 of Nokia in the introduction, and it's the last line of the penultimate paragraph. Well, it's referring to Kobe. Which so this point applies obviously if my learned friend is right about Kobe, but we say that particular point only applies if you're using CCEs. It wouldn't apply with the control channel index. Then we have the point about the CQI gap, and my learned friend says it's a sleight of hand for Apple to look at what the base station is doing, and we say, well, that is effectively an acceptance that the base station of Nokia can do this. In other words, it can transmit a CQI with either one gap or a gap on either side, and we say that as long as the phone of Nokia can be induced to do that, and as I say, effectively, my learned friend accepts that the base station can induce the phone to do that. That's enough to produce the code multiplexing structure of the claim, and that is sufficient. My Lord, finally, on the Nokia anticipation, my Lord Justice Birss raised a point yesterday, and I can't remember whether my learned friend jumped on the bandwagon or not, but probably. And that is that there's a difference between not telling somebody to do something and then not being able to do it. And we say that all that matters for the purpose of the claims is that it doesn't happen, i.e. that there is a gap, and not why the gap is there. So it doesn't matter whether it's a positive command not to do it or an absence of a command if in practice the UE doesn't do anything in the gap. So turning then to points on the 810 patent, my learned friend accepted, as I understand it, that you construe the COBE agreement through the eyes of the skilled person, and we say that must be right, that was our submission, and that if that is right, then expert evidence as to what the COBE agreement means is clearly relevant. And we say...
Why so? If it's an issue of construction of a technical document, then of course you have the evidence of the expert as to the common general knowledge. But once the court has acquired the common general knowledge from the expert evidence, the issue of construction is one for the court, and the evidence of the experts as to what they think the document means is inadmissible.
Well, my lord, we would say that that's certainly not true when you're talking about technical terms. And obviously, if you look at the COBE agreement, it's not just simply...
So if there's an issue as to the meaning of the word control channel, of course, then
Yes.
the technical evidence is admissible. But
Yes.
that's not the kind of evidence you're relying on.
Well, my lord, with respect, we would say it is, because we say the issue is, what does control channel index mean? Does it mean control channel index literally, or would it be understood by the skilled person to be ambiguous?
Not as to the meaning of a technical term. That's what the sentence means in context. And on that, the evidence is surely inadmissible.
Well, my lords, we say control...
But of course, you can say there's an issue of evidence as to what the skilled person would think and do in the light of the document so interpreted. Then you have the different problem.
Well, that my lord earlier was talking about question 1 is the question of interpretation, and question 2 is then what you do with it. And we say we're on question 1, interpretation. That's the question that the court has to decide, at least at this stage of the analysis with the COBE agreement. And we say at that stage of the analysis, it is still legitimate and indeed appropriate to look at what the expert evidence was, because not only is this a technical document, it's a technical document with technical wording in it, control channel index, and therefore what the experts said about this is highly relevant. And for that reason, we say that what Mr. Bradford says it is relevant. And certainly my learned friend looked at Mr. Bradford's evidence, and we say that one of the problems with the judge's judgment is he did not deal with Mr. Bradford's evidence. And just so my lords have got in mind exactly what the position was at trial. At trial, we had one expert who said that it meant index of the control channel element. Our expert said that's what the COBE agreement meant. Mr. Bradford said it meant index of the control channel candidate, and that is a different thing from index of the control channel. And then we had the judges finding that it meant something different from either of those two things. In other words, it meant index of the control channel. And so we say that there were these 3, or 4th option being it's unclear what it means. And we say, very basic point to start off with, the fact that the 2 experts couldn't agree what it meant, it is certainly a signal to the fact that it's unclear. And moreover, Mr. Bradford's evidence was that it was unclear. Now, my learned friend attempted to do a sort of clever reading of his own expert's evidence, and we say that's not right. And I'm not going to go through those passages again, but I do ask my lords to look at them, and look at them with this particular point in mind, which is paragraph 184 of the judgment. And paragraph 184 has a figure from a book called Dalman, and it was also a figure that appeared in Mr. Edwards' evidence. And what the judge is saying, sorry, this is on page 101 of the core bundle. What the judge is saying here is, finally, I ought to mention that in addition to the possibility of using the CCE or the control channel index, the oral evidence at trial touched on the possibility of using the index of control channel candidates. And he then sets out this Dalman figure, which shows that you've got the control channel elements on one side and the control channel candidates on the other side. In other words, possible control channels, not the actual control channels. And the reason for pointing that out is because when my lords are reading the passages of evidence from Mr. Bradford, he is talking about the control channel candidate index, not the control channel index. And so my learned friend said, all he's saying is that the control channel index isn't clear, not that the COBE agreement isn't clear. And in my submission, that isn't right. And it's helpful to know that both I think 2 out of the 3 passages, Mr. Bradford is being cross-examined on this figure, and so that helps to understand what those passages mean.
Thank you. That is actually helpful, because I was about to ask you what exactly a control channel candidate was, so you've anticipated that. I'm very grateful to you. Can I just make sure? Again, another penny's just dropped. I think is this right? That this whole control channel candidate business is what that other case was about.
Control.
Which you probably weren't
Trial
in.
C.
But yes, my lord and
My
lord.
favourite case.
Right. Okay. Because that was all about. Because the phone has to do blind decoding of control channel elements, and, and rather than trying to blind decode everything, you give it a candidate set of things saying this is the places where you need to look, and that's what that is.
Yes,
that's what this is.
yes, and of course the difference between a control channel candidate and a control channel in terms of indexing them is that the UE knows what the control channel candidate is.
Because you're telling it that, so that's to
yes. Whereas it doesn't know what the control channel index is. And so, at the end of the day, obviously, our point, which my lords have already, is that we say that the COBE agreement is ambiguous, and that is supported by the evidence of Mr. Bradford and other points that I won't repeat again.
I mean, just at the risk of saving Mr. Hinchcliffe a heart attack, I think what he says is that Mr. whatever rich expert it was, forgive me for forgetting, it doesn't matter, wasn't saying that the COBE agreement meant you should use the candidate. It was saying Mr. Hinchcliffe's case is that would be a way of putting into practice what he said, which is not quite the same thing. But
yes,
I understand
but our point is he clearly says that the COBE agreement itself isn't clear, as opposed to just saying that the control channel index isn't clear. So, moving on to construction of the 810 patent, I won't say a massive amount of this, but it is important to remember when we're talking about construction of the 810 patent, and indeed also in relation to obviousness, what our submission is about the meaning of the COBE agreement. And we say the meaning of the COBE agreement is implicit signalling, but it's ambiguous as to the way in which that should be done. And that's what the skilled person takes from it, that it's ambiguous. Now, my learned friend likes to parody my submission, excellent oratorical device, and say, what you're saying the COBE agreement means is that control channel index is technical nonsense. And that's not what we're saying it means. We have a point which is that there is a technical difficulty with what the COBE agreement means, and this is one of the reasons we say it's ambiguous. But that is a point where my learned friend says, oh no, there's not a technical difficulty at all, because his case is you can do it. And so, as I think I said in opening, the fact of the matter is we've both put our cases too high. So our case is that the meaning of the COBE agreement is ambiguous. It's not that the meaning of the COBE agreement is control channel index is technical nonsense. And so we say that's what you're thinking about when you're construing the 810 patent, insofar as it's relevant to have regard to the COBE agreement. The COBE agreement is ambiguous, and so it effectively doesn't help the skilled person either way when construing the 810 patent. And then, of course, we have our point about the fact that association is a much wider word than mapping. And with due respect to the amusing example given about cricket, we say that simply doesn't help. I mean, if one wants to continue with that example, we could say, well, actually, if you're a friend of someone who's a member of the club and you're associated with them, then you can get into the club, and there is a link, therefore. But the point is here that the word mapping is used in the description, association is used in the claim, and a further point made by my learned friend, or his attempt to respond to the number, the absence of the reference to CCE number, is that nothing about CCEs was disclosed in the description other than their number, and we say no, that's not right. What is also disclosed in the description is the fact that the L1, L2 channel is made up of CCEs, and in various paragraphs of the description there is a link made between the number of the L1, L2 channel, the fact that it's made up of CCEs, and then the number of the putsch. And moving finally on to the obviousness case, we say, again, the problem here with what my learned friend is saying about our case is that he's parodying the way we put it. We say that, as indeed he does, that it is, of course, technically possible to use the control channel index, and for that reason, we say, based on all the evidence in the case, and in particular on his expert's evidence, that is something that it would be sensible and obvious to do. And I've already given my lords, I think, the reference to Optis' skeleton, and also made clear our reliance on Panasonic.
So the obviousness case that you're putting is that it would be technically what you say would be obvious to do is to use the control channel index.
Yes.
And you, as I understand it, you're not saying that it would be obvious to put that into practice by using the control channel candidate index.
No.
That's not your case.
No.
So a skilled person who fleetingly contemplates using the control channel index in this context, what would they actually do?
Well, they would develop a logical index in the way that my learned friend's skeleton sets out at paragraph 57 of the Optis skeleton. The evidence that it would be technically possible, this is of our witness, it would be technically possible to index the control channels themselves, and at the end of the paragraph, the skilled person would assume that a logical ordering would be made clear. So we say that
By adding extra signal.
yes, exactly.
And why is that an obvious thing to do?
Well,
when it's a known desideratum to use as little signalling as possible, and not to have extra signalling.
well, my lords, both of the experts agreed that it was technically possible to do it.
All right, but I'll ask the question one last time. What evidence of either expert do you rely upon in support of the proposition that this was an obvious step to take?
My lord, I rely on the evidence in this paragraph and also what is in Panasonic.
I take that as an answer that you don't rely upon any evidence of any expert saying it was obvious.
I don't have specific evidence saying that. No, that's right.
Thank you.
My lords, can I just check whether the rest of the team wants me to say anything else? No. And do my lords have any questions?
No, they seem to be exhausted, Ms. Lane. Thank you both very much for your submissions. Thank you too for everyone else in court for their contributions. You will not be surprised to know that judgment will be reserved. In accordance with what has become the practice, it will be handed down remotely without obviously any need for attendance. There will indeed be nowhere to attend. You will, of course, be given the judgment in advance for you to correct typing and similar matters, but not to re-argue the case. And in accordance with what we normally do, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to rule on the points in the order that we make. Finally, I ought to remind you of the embargo. I'm sure the bar is now very well aware of the Court of Appeal's concern that the embargo should be complied with, so please make sure that you do. But thank you again.